Hi friends, welcome to Law Chat 101. This is your legal BFF, Girija Patel. I am going to be sharing with you today how to enforce your contracts. Now, before I do that, two things. Number one, if you love this episode, and I'm sure you will, and you have gained information out of this episode, and I'm sure you will, there are so many more episodes just like this that you do not want to miss. So make sure you subscribe to Law Chat with Girija on YouTube and also on all your platforms where you hear podcasts, because we have the most wonderful guests on our podcast as well. And then if you love it and you think others will also benefit from it, because I'm sure they will, so share it with your friends and your family, share it on your social media, share it where you think others can benefit from it as well, and tag GBP Law or Law Chat with Girija at the same time so that we know and we can say hi to you as well. Now, number two, the thing I wanted to talk to you about is that the information that I am sharing with you today on this episode of Law Chat 101 is for educational and for informational purposes only. It is not creating an attorney-client privilege between you or me, or a relationship between you or me. And this is really just for your benefit, for your education. And if you do need a lawyer, please go contact a lawyer that can help you specifically to your business. But with that being said, let's get started. So I get this question so many times, and it is, how do you enforce your contracts? Yeah, we have these contracts in place. Wonderful. Now what do we do? Well, number one, I am so happy you have that contract in place, because it is getting you places. Plus, it is also giving you the confidence and making your business seem more legit. And also you feel like it's more legit. So you treat it like a business and not some side gig or something that you're not taking seriously. And the person across the table from you is also taking it seriously. But when it comes down to the nitty gritty, how do you apply the contract? And what I mean by that is, how do you enforce it? How do you make sure that, okay, now I have it, people have signed it, now what do I do? Well, number one step that I really want you to do when you have a contract is read your contract and understand your contract. Make sure that when you have a contract in your business, that it's not just something that you downloaded and you have blindly just inserted or inputted all the information, if it was a template, or if you have it from a lawyer, that you haven't just taken it from the lawyer and just giving it out to your client without really truly understanding the contract and understanding what it means. Because number one, you have to be effectively communicating this contract with your client, and you cannot do it if you have not read it, and you cannot do it if you do not understand it. So it is so important to read and to understand. You don't want to be told by your client or by any other third party that, hey, this is what your contract says, and you're like, oh, I didn't even know that, because your policies don't work that way, your operations don't work that way, but your contract says it. So it is absolutely going against the grain of your business, but you have to now stand by it because it is in your contract. Number two, make sure your contract is aligning with your business practices. So these number one and number two, these are things that you need to do in order to prepare to enforce a contract. If something is not aligned with your business practices in your contract, and your business practices say something else, you're gonna have friction. And the friction will start from you saying, wait, you can't do that. And then all of a sudden you realize that, oh gosh, my contract permits this third person, whether it's a client or whether it's a vendor, whether it's somebody else, another business partner of yours, it permits them to do a certain act or lack of an act because the contract permits them. So read the contract, understand the contract, and then also make sure that the contract is aligning with your business. And when that aligns with your business values and the operations and the systems, you're going to have less friction with your contract and with the third person that you are working with. Number three, so now you're in a conflict. What do? Sometimes you go back and forth on email, or you'll have a phone call with somebody and you're trying to resolve it. Well, your contract should actually tell you what to do. That should be part of the contract. It should outline, giving you a step-by-step process on how to handle conflicts, how to handle issues or disputes that are coming out of that business relationship. And so again, you want to confirm that that process aligns with the way your business runs, and it aligns with the way that you would want to figure out how to handle this problem, whether you're giving refunds or whether you're not giving refunds, or whether you're saying, hey, give me some notice, like give me a proper notice in order for me to know that there's something wrong. and give it to me within XYZ days of the actual problem or dispute at the time that it happened. So that way people know the process and they're giving awareness of it and they're giving awareness to you. So you have time to cure the problem. But then you can also go back and refer to your contract. Your contract should be giving you the step-by-step process on how to do it. It should give you time to cure the problem, time to remedy the problem, and it should also give grace to all the parties as well to fix the problem and to also allow you or the other party to say, you know what, we will allow this one time, the next time this is not going to happen. So allowing yourself the waiver of waiving an issue, but next time not losing that right to enforce the contract if you need to. Number 4, after you have gone back to your contract and you've referred to your contract, what you can do when there's a dispute that arises is that copy paste that portion of the contract that applies to maybe the dispute itself, and also the process in which you need to resolve the dispute, and send it to the person that you are having this issue with and tell them, hey, listen, this is what the contract says. This is how we're supposed to be resolving it. So let's do this. And so you have a step-by-step process of how to do it. Now, don't be scared to stick to your position if you want to. Now, whether you're on this side of the contract or this side of the contract, don't be scared to stick to the position, especially if you believe that that's where the truth lies for you, or if you believe that this is something that was done wrong. You can stick to your position, but also be open to compromise, also be open to negotiations, because ultimately most cases that go into court are settled outside of court. What does settlement mean? Settlement does not mean that one party goes out with a ton of things and everything that they want on the checklist, and the other party, which is probably the party that you're against, gets nothing on that checklist. Absolutely not. So what does negotiations and settlement mean? It actually means that people are walking out, not 100%, but at a point where they're happy, they've compromised, they've done some give and take, but they're walking out with something, but they're not 100%. So why don't we avoid all the trial costs and all of those other extra costs that might be attached to pre-trial, and try to do this on your own when you know that there's a friction, you know there's a problem. Have that conversation with them. Don't be afraid to stick to your guns, but also don't be afraid to show the compromise and the flexibility that's needed to make this contract or this business relationship move forward, or at least what your goals are to move forward. Number 5, memorialize everything that you are writing and talking, right? So why and what does that mean? So if you're having a conversation with somebody on the phone and you know that this could be something that a dispute is coming out of, there's something brewing in the back, or there's already something that you know about, having a conversation on the phone is wonderful, but I need you to create a follow-up email to that conversation to memorialize that conversation. And it should happen sooner than later, because it is showing your direct information and your reflection of the conversation, and then you're writing it and you're sending it out. That way they have a chance to read, review, and if they have any discrepancies, they can reply back. But also you will have the memory fresh in your mind, and you can quickly write it down and send it out as this is a recap of the conversation that we had. These are the things that we discussed about. This is the stuff that we're going to be thinking about. These are our positions. This is our action items, whatever. Write it down and memorialize it so you have a record of that conversation now, and it's not just a he said, she said thing on the phone. And number 6, ultimately decide what solution works best for you. So collecting all of this information that I've just shared with you, it is ultimately in your hands to figure out where you're going to compromise, to figure out where you're going to stand firm and tall, to figure out how you're going to negotiate it, and to figure out also what is okay with you. And sometimes that okay might just be to terminate that relationship altogether and have an exit strategy at that point in time. And with that being said, you should have a contract termination or contract cancellation, like a letter or a little mini contract, half a page long, not even that much, just to reflect what the termination terms are, the cancellation terms are. So that way both parties have an understanding of what they're agreeing to in order to exit this contractual relationship. And then also at the end of the day, this will be the end of it. And they're agreeing that the terms that they've agreed to now is the end of it. And so nobody can come back later and say, oh, wait, but you still owe me this. And then you say, no. This cancellation clause that I have right here, you here agreed to that this is the end of it, and you're going to be okay with me giving you this much money, or you're going to be okay with XYZ terms at the end. And you agreed to it, your sign's right there. And so that way you can refer back to what you've negotiated on, where you have settled, where you are okay and happy place for you. And you've also shown another instrument to memorialize that agreement, and not an email, but an actual written document with both of your signatures on it. And remember, always stand firm, stand tall, but show the grace where you need to show it. Show the ease and the flexibility where you need to show it. But don't be afraid to negotiate, and don't be afraid to stand to the points that you believe firmly in. Until then, I will see you again, but remember, subscribe so you can get more of this information from Law Chat 101 and other tips for the business and for legal tips as well for your business. And share the love and share with your family, friends, your community. I will talk to you again and see you next week.